tuned in to The Andrew Lawton Show.
Let's talk about that Toronto Star piece. Let's put that up again, Sean. Have you heard the one about Justin Trudeau attacking your free speech online? Trust me, that's just rage farming by Supriya DTI, contributor. Okay, now what's unique about Supriya DTI? She's a lawyer, she's a former talk radio host, but you scroll way down in the bottom of the article there, you get the key part here. Supriya DTI is a senior advisor to Prime Minister Justin Trudeau and was a former columnist for the Toronto Star. She is a Trudeau staffer. She left her career. She was working, I believe, at McGill University in one of their digital media centers, but she left that to go and work for Justin Trudeau. Okay, that's fine. I don't know why. That's like boarding the Titanic when you're about 3/4 over the Atlantic. It's already hit the iceberg, but hasn't gone down yet. And you're like, well, the food on that ship looks great, so let me get on board. But nevertheless, Supriya decided she wanted to go on to Justin Trudeau's team. She wanted to be a part of the Prime Minister's office. She is a senior advisor. Nothing wrong with that. Our system relies on people advising the government. But she is also now the spin doctor of this piece of legislation, which I find very, very strange. Political staffers are typically not the ones putting their bylines on columns. Political staffers are not typically the ones doing interviews to sell or champion legislation. I mean, my thinking, and I mean no disrespect to Supriya on this, was there no Liberal member of Parliament that wanted to put their name on a defense of the Online Harms Act in the Toronto Star? Was the Justice Minister who is selling this bill perhaps unavailable or uninterested in doing this? But she talks about criticism of this bill being rage farming. Rage farming, that's the term she uses, rage farming, which is basically just trying to gin up hatred online. She talks about this as though there are no legitimate critiques or criticisms of the bill, because she's appealing to authority here. She's defending the bill. When we talk about the hate speech stuff, it prohibits speech which is fomenting or likely to foment detestation or vilification. The language comes from a Supreme Court decision, but that is not the defense that she and other defenders of this bill seem to think, because the Supreme Court left a very confusing decision there that doesn't actually give much in the way of clarity when you want to see how a human rights tribunal is going to adapt that decision to individual expressions of speech. But let's get into where I believe she is factually wrong. Again, I am not a lawyer. I cover legal issues. I interview a lot of lawyers, but I am not a lawyer. So I was fully prepared to admit that I might have been misreading something, or I might have been getting something wrong. The more feedback has come from other sources, the more I am convinced that is not, in fact, the case. Because Supriya said this on Twitter. After one user said the bill threatens life in jail over nasty comments to politicians, DTI responded by saying, that's not what the bill does. A max of life imprisonment for hate has to accompany an underlying act that is also punishable by max life imprisonment. So if you attempted to murder someone on the basis of their race, religion, sexual orientation, etc. So what is at stake here is the amendment to the criminal code that the Online Harms Act puts forward, which says if a criminal offense is motivated by hate, that criminal offense could carry, oh, you gave it away, Sean. You gave it away. No, take that away. Take that away. Yeah, okay. I was going to like just bombard people with that at the end to make the point dramatically. It's a little less dramatic now, but we'll work on it. The bill says that, if you add an offense, or if you add hate motivation to an offense, it carries a life sentence. Now, Supriya was very clear that no, this will only apply to things that already have a life sentence. Now, she also criticized Andrew Coyne, making the same argument I've made on this on the show. He made it in a Globe and Mail column. Supriya said this about Andrew Coyne's contributions to the matter: probably unhelpful to the discourse when our national newspaper lets columnists just make all sorts of stuff up about the bill. Coyne is demonstrably wrong here. So that is, again, her saying that if you make the claim that this bill could theoretically put a life sentence on someone who vandalizes the side of a mosque or the side of a synagogue, again, wrong, I'm not defending the act, that could carry a life sentence. Now, we've talked about this on the show. Judges are unlikely to give a life sentence to someone who does that. But the point is that the criminal code will, if this bill passes, make that possible. critics have said, including me. That is my reading of the bill. Supriya says in her point that is just wrong. Now is time, Sean, for the dramatic reveal. Let's consult with the legislation. Everyone who commits an offense under this act refers to the criminal code, or any other act of parliament, if the commission of the offense is motivated by hatred based on race, national or ethnic origin, language, color, religion, sex, age, mental or physical disability, sexual orientation, or gender identity or expression, is guilty of an indictable offense and liable to imprisonment for life. If you commit an offense that carries theoretically a sentence of less than 2 years or not even a jail sentence, this bill says that will be, if motivated by hate, an indictable offense, which means you're talking about a prison term of 2 years or more, up to life in prison. That is what the legislation says. Now, I very politely pointed this out to Supriya. And again, I loaded my tweet up with caveats because I said, I am not a lawyer here. I could be wrong. If I'm wrong, show me. And I just said, please provide a citation. This was her response to me. She says, it's a more than fair question. The answer is that you and others are reading the legislation in complete isolation from the binding principles of common law that apply to sentencing and bind sentencing judges, not to mention Section 718 of the Criminal Code, which she shared a screenshot to, which basically says sentences must be proportionate. But no one is talking here about proportionality. We're talking about, does this bill fundamentally alter the maximum permissible sentence based on motivation? The legislation says yes. Supriya is saying no. She says that we are actually not allowing this to change anything that doesn't already have a life sentence. Now, that raises the obvious question, which I put to her because we were having a very civil exchange on X, and I said, okay, well, what's the point of it then? What's the point? This was her response. She says here, the honest answer is that it explicitly denounces hateful conduct. The standalone hate crime provision will make it much easier for law enforcement to track hate crimes across jurisdictions because right now, when it's only considered an aggravating factor at sentencing, it's very inefficient. I've never heard this argument championed before. It may or may not be correct. I don't know. But it doesn't fundamentally change that this law is being misrepresented by the Prime Minister. Well, again, I don't know if the PMO sent her out to write that op-ed, but by someone who works for the PMO and has written an op-ed trying to defend this bill. It's just fundamentally wrong. Now, other people who are far more learned, who are themselves lawyers, have weighed in and mercifully have agreed with the plain text reading that I had of the bill here. Howard Anglin wrote that Andrew Coyne was right. It's exactly what it does. And he just says, your response is trust judges. Yeah, and that's basically the PMO's response here. They're just saying, well, judges aren't going to give a life sentence for something minor. The point is that this will override the current provisions on this and will give them that option. I want to welcome into the show Christine Van Geyn, who is the litigation director of the Canadian Constitution Foundation. We've talked about some of these concerns on the show in the past. Always good to talk to you, Christine. All right, who's right here, Supriya or yours truly?
You're right, Andrew. And
yes.
So are all of the lawyers who are on Twitter with Supriya, I guess, explaining the law to lawyers. As far as I know, is she a lawyer?
I don't know if she's a member of the bar. I believe she was a lawyer at some point, or at least went to law school. I don't know for sure though.
Okay, so I take that back. But I have something that I think will entertain you, which is, I read this morning and was quite irritated. I wrote to the Toronto Star saying that if they're going to publish Supriya, who is a government mouthpiece. I mean, she's...
Yeah, literally. I don't even mean that in the way that we often talk about some left-wing columnists. Like, she's literally a PMO staffer.
She works for the Prime Minister. If they're going to publish that, then they should, and allow the critics of this bill, who are careful and thoughtful in their criticism, then they should allow a rebuttal. And they've agreed, and they're running my rebuttal today. I've written one, and all credit to the Star for agreeing to run a rebuttal to Supriya's piece. So I'm excited that they're going to run it, but I'm a little worried that her meltdown will continue, and I will now be target of the meltdown. But I mean, I think someone needs to set the record straight that criticism of this bill is not rage farming. It is not bad faith. I think the government would do well to remember that freedom of expression in Canada and is a fundamental right. It is actually a precursor to peace and security and democracy. It is not a threat to our society. It's what makes our society possible. And the government should, instead of attacking critics of the bill, which include academics from across the political spectrum, the more than 6,000 people who have written to their members of parliament through the Canadian Constitution Foundation's online platform expressing their concerns with the bill, the Canadian icons like Margaret Atwood who've expressed concerns with this piece of legislation, as well as lawyers and academics who actually will be the ones engaged with applying this law. All of that criticism is something that the government should be listening to, not attacking and saying we're rage farming. I mean, no farming is necessary. People are angry, and it kind of springs up naturally. Like, I don't need any fertilizer for this.
Sean, can you put up tweet 4 for a second again? This is the common law, the principles of common law one from Supriya. I want to get your take on this, Christine, because one of the points that Supriya raises here, she said, no, it's the other one. The principles of common law one. She says here, no, we'll keep going. We'll get there eventually. There we go. The honest answer is, sorry, go back to the other one. This is the great thing about live media. So she says here that basically that you can't look at the legislation as a standalone or a separate from principles of common law is basically the thing. We don't have the tweet, but that's fine. You can't look at it separate from common law principles. And as I understand it, and please correct me if I'm wrong here, because as I've caveated up the wazoo, I'm not a lawyer, but statute kind of overrides common law, does it not?
So I do think that Supriya has a point here in saying that judges will apply principles of proportionality that are already in the criminal code. Section 718.1 of the criminal code deals with sentencing, and there's proportionality sentences. There's also common law application of sentencing that you wouldn't have a disproportionate sentence. But I think that that's true. That the legislation does make the things that we're all saying possible. So it certainly would be possible that if you peg on hate as the motivation to any of these offenses, that the government, the Crown, the prosecution can argue for life. They're unlikely to get it. It will relate to the underlying offense. But it's certainly possible for them to argue it. And I think that that's a really important point, because what we're not talking, the risk isn't just in whether a court will sentence someone who engages in, for example, mischief motivated by hate or vandalism motivated by hate. It seems unlikely that the courts would give them life imprisonment. But what this legislation does is it allows the Crown to add the hate motivation onto any offense, including a minor offense like mischief or vandalism. And that gives the prosecution the power to threaten far, far, far higher penalties for minor offenses that they can then use to pressure a defendant to plead out, including in cases where a defendant shouldn't plead out because perhaps they are poorly represented, the hate threshold isn't met. This is most likely actually to happen to people who are marginalized in our society, who are less able to afford a judge. So it's actually going to end up hurting the most marginalized people in society. And look, I'm not saying that vandalism or mischief, if it's motivated by hatred. And I think some classic examples are the desecration of cemeteries or spray painting offensive symbols onto religious places of worship. I mean, those things, the people who commit those offenses should have an intervention, and a criminal prosecution could be a part of that. But allowing the Crown, the prosecution, to hold this threat of huge penalties by tying the prosecution to a hate offense really, that's the on-the-ground application of this law. That's really dangerous. Someone on Twitter also pointed out to me that by adding a hate offense, if the person is an immigrant, has immigrants some type of permanent residency, it could be used against them in a deportation proceeding, even if the charges are not made out. But by having a minor offense moved into a more serious offense category. So there's all kinds of spillover effects that Supriya is frankly ignoring, that good faith critics of this piece of legislation are pointing out. So I'm glad the Star's running my rebuttal, because I have a lot to say about it.
No, so am I. And I think your point about it's easy to focus on judges. And again, an argument that hinges on trust judges is not, in my view, the most compelling one. But even if you do,
it's Supriya's article is trust me. Trust
trust government. Yeah, trust the
PMO.
That's the. But you are right too. I mean, when you talk about that categorization of offenses, it isn't just about the possibility of a life sentence. It's also about taking things that would normally be dispatched with a fine and putting them into indictable offense territory.
Yeah, I mean, and it's the threat. It's a threat, even if the person, perhaps they have not made out the threshold for hate speech. That they have the threat now to plead out because there's this thing hanging over their head that there's a much more dangerous offense that they could be convicted of that comes with a much more serious penalty. So, I mean, Supriya's article makes a huge number. A lot of these are just straw man arguments, right? Like, throughout her article, one of the big things that she focuses on is this criticism a lot of us have of peace bonds. And she says that, peace bonds, the critics of the peace bond provision is that members of the public, with the consent of the Attorney General, can seek a peace bond to put restraints on people for future speech. So if there's reasonable grounds to believe that a person will engage in hate speech in the future, a court can order all kinds of restraints on speech, including things related to access to the internet. They can even impose house arrest or electronic monitoring, like an ankle bracelet. And people have raised a lot of concerns about this for obvious reasons. And Supriya says that critics of the peace bonds are misguided, that we're rage farming because peace bonds are not a novel.
She blames the right-wing online ecosystem first and foremost. So I think that's me. I believe I'm part of that, because she mentions people invoke Minority Report, and I literally did that like 3 days ago. So I think I might be obliquely or directly in the crosshairs on this one.
I mean, the reality is that no serious critic of this bill is suggesting that the Liberal government invented peace bonds in this piece of legislation. We know that they exist. The critics, including us, are saying that the problem is a peace bond for future speech, because that in itself is inherently speculative. And in her article, she compares these peace bonds for future hate speech with peace bonds for stalking or terrorism. And I just don't think that this helps her argument at all, because terrorism, courts can be a lot more certain about the risks involved. It's really obvious if someone has bought materials to buy a bomb or build a bomb. And there's also a lot more certainty about what terrorism looks like. Whereas with hate speech, the court needs to speculate and get into the mind of a person about what they may say in the future and whether it meets the threshold for hate speech. And that threshold, which comes from a Supreme Court decision in Whatcott, is a really squishy, speculative, and subjective definition. So hate is defined as detestation and vilification. And I mean, frankly, these are synonyms for hate. So hate is defined by reference to itself. It's not especially helpful. And I think when you've empowered the public to seek peace bonds against fellow citizens using a definition they're unlikely to understand, you really are creating a chill on speech. And this is what the critics of the bill are saying. We are not saying that a peace bond is a new creation by Justin Trudeau. We're saying this is a bad application of a peace bond, and there are serious risks associated with it.
We're going to attempt to do a tweet again. Maybe we should just avoid it here. But this is a Supriya tweet. Starts with the honest answer is that it explicitly denounces. So this is in response to me saying, if your claim is that this will only apply to things that already have a life sentence, what's the point of it? She says that it will make it easier for law enforcement to track hate crimes across jurisdictions because it's inefficient when it's only considered an aggravating factor. I'm having trouble following the argument here, but I was wondering if you could weigh in on this at all.
No idea.
If this is
I have no idea what she's talking about. Okay. I think the goal that the government has is they want more prosecutions for hate offenses, and this is the way to achieve it. So right now it is treated as an aggravating factor, but there also are standalone hate offenses already in the criminal code, right? There's provisions about public incitement of hatred and willfully promoting hatred. And they're not, especially on the public incitement, there have not been a lot of prosecutions because the threshold is really high, and it's supposed to be high. I mean, we're talking about criminalizing speech here, which is something that's fundamental to our functioning as a democracy. So I don't really, I think what the government wants is more prosecutions for hate offenses. This is their way of attempting it, but I don't understand her justification here. I just don't know what she's referring to.
Okay, no, that helps me. I thought I was the moron for not being able to figure it out. But let me just ask you about the problems with this, because the government, they always do the, oh yes, well, we'll talk about this in committee, but for the most part, they aren't really admitting that they got anything wrong here. They've had years. This was first put forward, or a version of it, in 2021, shortly before the election. They've been promising it basically since that election. They were first promising it within the first 100 days. It's now 3 years after it was first tabled. So do you think this is sloppy, or do you think everything in there is very deliberate and that's exactly what they wanted?
I think that there is zero consideration for how this will actually be applied on the ground. And I think, Andrew, you should interview some criminal defense lawyers to talk about their concerns with the law, because they're the ones who are going to actually be representing people who are now going to be facing this sledgehammer from prosecutors to increase the severity or the potential range of sentences for otherwise minor offenses. Supriya says this is something that we don't need to worry about. Perhaps the government hadn't thought about how this law would be applied on the ground, because they're, bureaucrats, including in justice, in the Justice Department, they're not the ones who actually work and engage with, people who get charged with crimes. So they might not really understand how this could play out if you give the prosecutors this massive tool.
Yeah, very well said. Look forward to your response op-ed in the Toronto Star, not written by someone from the Prime Minister's office, blissfully. Christine Van Geyn, litigation director at the Canadian Constitution Foundation. Always a pleasure. Have a great Easter weekend.
Thank you.
Thanks for listening to The Andrew Lawton Show. Support the program by donating to True North at www.tnc.news.